A very warm welcome to all. Today, I, Reeya Khanna, an intern under LEXIS and Company, am here to express my views on rights of HIV positive person in India. This is the part 2 of the video, and in the previous video, I had shared introduction about HIV, what is HIV and what is AIDS, and how they are different. Further, I explained the definitions of HIV and AIDS according to the UNESCO guidelines, that HIV stands for human immunodeficiency virus and AIDS stands for acquired immunodeficiency syndrome. Further, I explained the relationship between HIV and human rights. After that, I gave a little glimpse into the human immunodeficiency virus HIV and acquired immune deficiency syndrome AIDS Act 2017, which got the presidential assent on April 20th, 2017. Over there, I explained the 5 main points of the Act. Now, let us understand certain landmark cases related to HIV and AIDS. First, in the case of IB versus Greece, the facts were the complainant was dismissed from his position in a jewelry business after testing positive for HIV. While the complainant was absent on leave, several of his co-workers, suspecting that he could be infected with HIV, underwent HIV testing. The results were negative. Soon afterwards, the complainant's co-workers learned that the complainant had tested HIV positive. A group of workmates immediately demanded the management remove him from the workplace. Approximately half the manpower signed a petition urging that the complainant be removed. While the employer was initially supportive of the complainant, she soon ceded to the pressure placed upon her by the employees and dismissed the complainant. The Greek cassation court held that the employer's decision to dismiss the complainant did not constitute discrimination, but was instead justified in the circumstances given the pressure that the employer was under and the danger posed to the smooth operation of the enterprise by the complainant's continued presence. What the court held was that the European Court of Human Rights reversed the Greek cassation court decision, finding that the employer had unfairly discriminated against the complainant, violating Article 14 of the European Convention on Human Rights. The court cited ILO Convention number 111 and recommended number 200, referring extensively to the recommendations provision on non-discrimination. The court held that by terminating the applicant's employment, the employer had further stigmatized a person who, even though was HIV positive, had shown no signs of illness. The court also found that the co-workers' threats were irrational as they were not based on valid scientific evidence. The court held that if the applicant's HIV status was not disturbing the smooth operation of the enterprise, his HIV status alone could not be a legitimate basis for terminating his employment. In another landmark decision by the Sri Lankan Supreme Court in 2016, the facts are that the Supreme Court had issued the directive in response to a fundamental right violation petition filed by Chandani De Soya in February 2016. Ms. De Soya is from the rural community of Ilukhena, Puliya Pitiya in western Sri Lanka. She was left in difficult circumstances when she lost her husband in September 2015. Ms. De Soya believed strongly that her 5-year-old son was entitled to an education and tried to enroll him in the local school. However, the school system denied the boy entry because a rumor was circulating that his father had died of AIDS-related causes and that the boy was HIV positive. The court held the court's directive, which was released on 28 April, stated that the right to an education of children living with or affected by HIV must be upheld based on the country's constitutional directive of universal access to education for children between the ages of 5 and 14-year-old. The Supreme Court also went a step further, reminding the state of its obligation to take necessary measures to protect, promote, and respect the human rights of people living with HIV. This is the first court decision in South Asia to make a general pronouncement recognizing the human rights of all people living with HIV and set a precedent for further cases in Sri Lanka challenging HIV discrimination experienced in setting other than the education. The last case is Canada Attorney General versus Thwaites, 1994. The facts of the case are that the complainant was Simon Thwaites, a master seaman in the Canadian Armed Forces. He filed a complaint against the CAF alleging discrimination because it had terminated his employment and restricted his duties and opportunities based on his HIV positive status. Under the Canadian Human Rights Act, the complainant sought an order that the Canadian Armed Forces had engaged in unlawful discrimination based on his disability of HIV infection, compensation for the past and future lost wages, and special compensation and legal costs. The court, in the judgment, the federal court upheld the original ruling by the Canadian Human Rights Tribunal that the Canadian Armed Forces had engaged in unlawful discrimination based on disability and awarded damages to Thwaites. And the Thwaites was one of the first decisions in the world to address the issue of discrimination within the military against people living with HIV. As can be seen from some of the other cases summarized here, courts in numerous other jurisdictions have not taken such a human rights focused approach to cases of discrimination against HIV positive military personnel. Aside from the issue of HIV related discrimination in the specific context of military, the Thwaites decision set an important precedent in Canadian law for those who continue to work while living with HIV. In conclusion, I would like to conclude that human rights are essential to any reaction to HIV. This has been perceived as the principal worldwide AIDS system was created in 1987. Human rights and general well-being share the objective of advancing and securing the prosperity of all people. The advancement and security of human rights are important to engage people and groups to react to HIV, to decrease helplessness to HIV contamination, and to decrease the unfavorable effect of HIV on those influenced. The frequency and spread of HIV are excessively high among gatherings who, as of now, experience the ill effects of an absence of human rights insurance and experience separation. The privilege of individuals living with HIV frequently are disregarded on account of their assumed or known HIV status, making them endure both the weight of the infection and the noteworthy loss of different rights. Defamation and separation may deter their entrance to treatment and should influence their business lodging and different rights. This thus adds to the helplessness of others to contamination, since HIV-related disgrace and segregation debilitates people contaminated with and influenced by HIV from reaching well-being and social administrations. The outcome is that those most requiring data, training, and advising won't profit even where such administrations are accessible. Thank you.